about Missouri's gun laws are being called into question again following the tragedy in Texas.
It's just a shame that those things occur, that kind of multitude.
Signature on 2 opposing petitions regarding gun regulations.
In Missouri cannot enforce federal laws that aren't also reflected in state laws.
For gun safety, which is a not-for-profit group, Missouri has some of the weakest gun laws in the country.
Lead, and we were solving gun crime after gun crime after gun crime.
Missouri's gun law. The recent Supreme Court decision denying a stay on Missouri's Second Amendment sanctuary law reflects a complex legal battle between the state and the federal government. In 2021, Missouri enacted the Second Amendment Preservation Act, asserting the state's interpretation of the Second Amendment and imposing restrictions on the enforcement of federal laws deemed inconsistent. The law specifically prohibits Missouri officers and agents from assisting federal authorities in enforcing federal laws that infringe upon the state's interpretation of the Second Amendment. The U.S. government challenged the law's constitutionality, arguing that Missouri's interpretation of the Second Amendment is incorrect and that the federal government's more limited interpretation should prevail. The legal dispute reached a critical point when the U.S. government sued Missouri, contending that the law is unconstitutional. The district court sided with the U.S. government, issuing an injunction that prevented the state and its agents from enforcing the Second Amendment Preservation Act. The law itself declares that federal supremacy does not apply to federal laws restricting or prohibiting arms, accessories, or ammunition within Missouri, claiming that such laws exceed the federal government's authority. Notably, the law allows any resident to sue a state agent or employee attempting to enforce a federal law that infringes on the individual's right to bear arms. The legal landscape is further complicated by the recent Supreme Court decision in the Whole Woman's Health case, which dealt with Texas's unique abortion law, SB 8. Similarly to Missouri's Second Amendment Preservation Act, SB 8 shifted enforcement away from the state and its officers, allowing private individuals to bring civil lawsuits against those involved in performing or aiding abortions. The Supreme Court's denial of a state in the Missouri case indicates that the legal battle continues, with the state persisting in its efforts to defend the Second Amendment Preservation Act. Despite the 8-1 decision against the stay, Missouri is undeterred and continues to fight back, emphasizing the significance of the legal principles at stake. The parallel with the Texas abortion law highlights the evolving legal strategies employed by states in shaping laws that deviate from traditional enforcement mechanisms. In both cases, the laws empower private citizens to take legal action, creating a unique dynamic in which the state's officers may not be the primary targets of legal challenges. The implications of these legal battles extend beyond the specific issues of gun rights and abortion. They raise questions about federalism, states' rights, and the role of private citizens in enforcing laws. The legal landscape continues to shift as states explore innovative approaches, prompting ongoing debates about constitutional interpretation, individual rights, and the proper balance between state and federal authority. Missouri 2A Preservation Act, a law designed to protect Second Amendment rights by allowing citizens to sue anyone involved in enforcing unconstitutional Second Amendment laws. The law's structure aims to avoid broad injunctions, giving citizens the power to hold state officials and their agents accountable rather than relying on the state to enforce the law. Missouri's law is part of a trend where states pass legislation asserting their commitment to specific constitutional rights and, instead of actively enforcing those laws, empower citizens to take legal action against the state if they feel their rights are being violated. This approach is seen as a strong statement of support for the Second Amendment. However, the district court reviewed and struck down the Missouri law, issuing an injunction against the state and its officers and agents. The court's decision raised concerns because the law was structured in a way that citizens, not state officials, were the ones enforcing it. Despite this, the district court issued a broad injunction against the state. Missouri appealed the decision to the 8th Circuit and requested a stay while the appeal was pending. The 8th Circuit denied the stay, prompting Missouri to file an emergency application for Supreme Court consideration. The Supreme Court, in an 8-1 decision, denied the stay. Justice Thomas was the only justice in favor of granting the stay. The order from the Supreme Court emphasized that the district court's injunction only prohibited the state of Missouri and its officers, agents, and employees from implementing and enforcing the law. Justice Gorsuch and Justice Alito added context, referring to the whole women's health case and expressing concern about injunctions that bind private parties not involved in the district court case or the challenged provisions. While the goal was to obtain a stay from the Supreme Court, the majority of the justices opted not to intervene in the early stages of the litigation, a stance consistent with the court's usual reluctance to become involved in cases before they progress through lower courts. Justice Thomas stood alone in supporting the stay, indicating a division among the justices on the matter. In rapid, the Missouri 2A Preservation Act represents a state-level effort to prioritize and protect Second Amendment rights. But legal challenges and court decisions have raised questions about the enforcement mechanisms and the involvement of the courts in these types of cases. The Supreme Court's denial of the stay suggests a cautious approach to intervening in state-level disputes at the early stages of litigation. Missouri 2A legalities. The focus of the discussed legal development revolves around the Missouri 2A Preservation Act, with particular attention to the response from Justices Alito and Gorsuch in the Supreme Court's 8-1 order denying a stay. An intriguing aspect highlighted by Alito and Gorsuch is that the district court's injunction seems to have a limited scope, applying solely to the state and its agents. Notably, private individuals who may wish to sue the state, its officers, or agents enforcing the law seemingly remain unaffected by the injunction. The Missouri law empowers citizens to take legal action against the state if they believe their Second Amendment rights are being violated, creating a unique mechanism for enforcement. Despite the Supreme Court's 8-1 decision denying a stay, there appears to be a nuance in the language used by Justices Alito and Gorsuch, suggesting that private citizens can still pursue legal action under the law, even if the state is restrained. Following the Supreme Court's decision, the state of Missouri responded swiftly by filing for expedited review of the case in the 8th Circuit. The reasoning behind this expedited review is attributed to the belief that the Supreme Court's denial of the stay has altered the status quo of Missouri's laws. The government's attorneys did not oppose an expedited review, and the 8th Circuit responded by granting the motion. The order sets the case for oral argument during the week of February 12th through the 16th of 2024. This development is seen as a small ray of hope in the case, providing an opportunity for a speedy resolution. Despite the Supreme Court's denial of the stay, the 8th Circuit appears to consider the recent events and aims to expedite the review process. In assumption, the Missouri 2A Preservation Act continues to be a subject of legal scrutiny and debate. The nuanced approach taken by the Supreme Court, the emphasis on the limited scope of the injunction, and the subsequent expedited review by the 8th Circuit contribute to the complexity of this case. Supreme Court blocks Missouri. In 2021, Missouri enacted the Second Amendment Preservation Act, a law designed to render federal gun restrictions null and void within the state. This legislation also aimed to prohibit state officials from enforcing any laws that might encroach upon the citizens' right to bear arms. Central to its structure, the law empowered any person to file lawsuits against the state law enforcement agencies failing to adhere to state law. The federal government promptly contested this state law, asserting that it unconstitutionally overstepped federal law, impeding federal authorities in Missouri from executing their enforcement duties. A federal district court sided with the federal government's argument, a decision subsequently upheld by the 8th Circuit Court of Appeals. Seeking a different outcome, Missouri appealed to the U.S. Supreme Court, contending that the lower court's rulings essentially curtailed the General Assembly's authority to define the limits of law enforcement in Missouri. Despite this plea, the Supreme Court, in an order issued on Friday, upheld the lower court decisions, maintaining the status quo and preventing the Second Amendment Preservation Act from being reinstated, at least temporarily.
About Missouri's gun laws are being called into question again following the tragedy in Texas.
Back in 2007, the state repealed legislation requiring background checks to purchase.
Joe Biden stood on the debate stage with all the other Democratic candidates and said, the firearm industry is the enemy.
It's just a shame that those things occur, that kind of multitude.
We had with our gun laws in the state of Missouri was the open carry.
Uphold and defend the Constitution, and he's calling me and my industry, which provides the law enforcement and the military their
violent criminals, and quit letting them go back and through a revolving door, letting them out.
Missouri's contention that the General Assembly's ability to shape law enforcement parameters is compromised by the lower court's decisions underscores the broader implication of the case. The state, by enacting the Second Amendment Preservation Act, sought to establish a precedent for local autonomy in determining the scope of gun-related regulations, a move met with resistance from federal authorities. The Supreme Court's decision to leave the lower court rulings intact has immediate consequences, keeping the Missouri law inactive for the time being. The dissent from Justice Clarence Thomas adds a layer of complexity to the case, hinting at a potential future revisitation or debate within the court on the constitutional aspects of state laws challenging federal authority, particularly in the context of Second Amendment rights. In immediate, the legal battle over Missouri's Second Amendment Preservation Act has reached a temporary conclusion within the U.S. Supreme Court, maintaining the status quo established by the lower courts. The dissent from Justice Clarence Thomas signals the existence of differing opinions within the court, foreshadowing the potential for further deliberation on the constitutional balance between state and federal authority in matters concerning the Second Amendment. Supreme Court denies. The Supreme Court's recent refusal to reinstate Missouri's Second Amendment Preservation Act, a state law prohibiting police officers from enforcing federal restrictions on firearms, marks a significant development in the ongoing legal battle between Missouri and the federal government. The case, Missouri v. United States, has been characterized by its implications for the enforcement of federal firearms regulation and the constitutionality of the state law. Missouri Governor Mike Parsons signed the Second Amendment Preservation Act into law in 2021, aiming to shield residents from what the state deemed unconstitutional federal firearms laws. The law explicitly prevents local law enforcement from implementing certain federal regulations related to arms, such as those governing registrations, sales, and ownership limitations. Notably, it includes provisions challenging federal restrictions on arm possession for individuals with felony convictions, imposing substantial fines for violations. However, a federal judge ruled earlier in the year that the Missouri law itself is unconstitutional, asserting that it unlawfully undermines federal authority and obstructs the execution of federal laws. This ruling prompted the state to appeal, leading to the emergency docket before the Supreme Court. In its unsigned order, the Supreme Court declined Missouri's request to reinstate the law, leaving the federal judge's decision intact while the state's appeal progresses through the lower courts. The lack of detailed reasoning in the order is typical for emergency appeals, and the justices did not elaborate on the factors influencing their decision.
These police officers come to work every day to keep people safe, but they're trying to interpret.
We can expect in the future that more people will be carrying handguns on the streets in places like Los Angeles, Boston, and New York City.
As many of you out there, either parents, relatives, and/or victims yourself.
Signature on 2 opposing petitions regarding gun regulations.
Because people buy hundreds of guns legally and then they sell them illegally.
Justice Clarence Thomas stood as the lone dissenter, expressing his inclination to grant Missouri's request. His dissent implies a divergence in opinion within the court, with Thomas potentially challenging the majority's stance on the constitutionality of the Missouri law. Justices Samuel Alito and Neil Gorsuch took a different approach by providing a separate clarification regarding their understanding of the scope of the lower court's order. Alito and Gorsuch's clarification adds a layer of insight into the Supreme Court's decision. Their statement suggests that, while the lower court's order prevents Missouri police officers from enforcing the law, it may not impede private individuals from pursuing legal action under the Second Amendment Preservation Act. This nuance emphasizes that the injunction's reach is directed at state enforcement entities rather than citizens seeking recourse through the legal system. The implications of this legal development extend beyond the immediate reinstatement of the Missouri law. The ongoing appeal in the lower courts will delve into the core constitutional questions surrounding the state's attempt to carve out expectations to federal arms regulation. The Supreme Court's decision not to intervene at this emergency stage maintains the status quo, leaving the federal judge's ruling in place for the time being. Governor Parsons' Second Amendment Preservation Act reflects a broader trend seen in various states attempting to exert local autonomy and defining the boundaries of firearms regulation, often challenging federal oversight. The Supreme Court's eventual decision on the merits of this case could establish precedent and clarify the balance of power between states and the federal government in matters related to gun control. In supposition, the Supreme Court's denial to reinstate Missouri's Second Amendment Preservation Act, along with the nuances provided by Justices Alito and Gorsuch, underscores the complex legal landscape surrounding state attempts to counter federal arms regulation. The case's trajectory, as it proceeds through the lower courts, will likely continue to shape the broader conversation on states' rights and federal authority in the realm of arm control. Missouri's firearm law battle. The legal saga surrounding Missouri's Second Amendment Preservation Act has reached a critical juncture, prompting the federal government to sue the state in an effort to block enforcement of the law. This legal dispute, which centers on the interplay between state and federal authority in the realm of firearm regulations, has garnered attention for its potential implications on the broader landscape of states challenging federal laws. In February 2022, the federal government, under the leadership of Brian Boynton, the head of the Justice Department's Civil Division, initiated legal action against Missouri. The objective was to prevent the state from implementing the Second Amendment Preservation Act, a law enacted in 2021. Boynton's statement emphasized that states cannot unilaterally invalidate federal laws and expressed concerns about the strain the Missouri law places on law enforcement partnerships crucial for combating violent crime. The legal battle escalated in March of the same year, when U.S. District Judge Brian Wims ruled that the Missouri law is unconstitutional. Judge Wims based his decision on the Supremacy Clause of the Constitution, asserting that state laws cannot supersede federal laws, which hold precedence. Effectively, Wims barred Missouri from enforcing the law, citing the fundamental principle that federal laws take precedence over conflicting state laws. Following this decision, Missouri faced another setback when, on September 29th, the U.S. Court of Appeals for the 8th Circuit declined to stay Wims's order.
Law is unconstitutional. It banned local police from enforcing federal gun law.
Are ones where, in fact, it's most likely that they should be bringing the highest and mandatory minimum.
For gun safety, which is a not-for-profit group, Missouri has some of the weakest gun laws in the country.
I'm just inspired by the next generation. I think it's a time for a big change.
The contention regarding standing raises broader question about the threshold for legal action, emphasizing the necessity for a tangible injury to confer standing. Missouri seeks to challenge the federal government's right to sue by asserting that it hasn't suffered a direct injury due to the state's refusal to allocate resources for enforcing federal laws. In decision, the legal battle surrounding Missouri's Second Amendment Preservation Act is characterized by its constitutional complexities and the clash between state autonomy and federal supremacy. The Supreme Court's role in interpreting the interplay between federal and state laws, as well as the threshold for legal standing, will likely have enduring implications for states seeking to challenge federal regulations. As the case unfolds, it serves as a microcosm of the ongoing debate over the balance of power between states and the federal government in shaping and enforcing laws.
In Missouri cannot enforce federal laws that aren't also reflected in state laws.
Are demonstrating that blind loyalty to Speaker Dade Phelan is more important than upholding their oath of office.
Lead, and we were solving gun crime after gun crime after gun crime.
Might end up being a message amendment because the President of the United States will almost assuredly veto it.
Plans on appealing this federal decision, saying that he's committed to defending Missourians' rights.
Types of disputes that would be settled by people yelling at each other, maybe engaging in a fist fight, are being settled with guns.
Missouri's law challenge. The legal showdown surrounding Missouri's Second Amendment Preservation Act reached another critical juncture when the Supreme Court rejected the state's request to reinstate the law. The heart of the matter lies in the clash between the state's assertion of its constitutional right to challenge federal laws it deems unconstitutional and the federal government's contention that Missouri is attempting to nullify federal statutes. Missouri Solicitor General Joshua Devine articulated the state's position, contending that the federal government's approach could set a dangerous precedent. He argued that if the United States could sue any state or state official expressing a contested constitutional view, it would create a chilling effect on law professors, state lawyers, and government officials. The state emphasized that it had the right to express its opinions on the Second Amendment and could prohibit state and local officials from assisting in the enforcement of federal laws it deemed unconstitutional. On the other side, U.S. Solicitor General Elizabeth Prelogar maintained that Missouri's law was an obviously unconstitutional attempt to nullify federal law. She acknowledged the state's right to express opinions on the Second Amendment and restrict state and local officials from assisting in federal law enforcement. Still, she emphasized that the state crossed a constitutional line by purporting to nullify federal statutes, directing state officials to treat federal statutes as invalid, and regulating and discriminating against federal officials enforcing those statutes. In its order, the Supreme Court, in line with its typical practice for emergency appeals, did not provide detailed reasoning for turning down Missouri's request.
Constitution are asking voters to decide if local governments or the state government should have the final say on gun law.
June of 2021, you changed the department's asylum rules so that it could apply to individuals with significant gang violence.
Most apparent here a defense of the Second Amendment, which this most certainly is.
Twime says the Missouri law exposes people to greater harm by interfering with the federal government's ability to enforce firearms regulations.
We are holding our law enforcement accountable. They aren't federal resources, they're Missouri resources.
The case serves as a microcosm of broader debates over the interplay between state and federal authority and the limits of a state's power to challenge federal statutes. The ongoing legal battle over Missouri's Second Amendment Preservation Act continues to raise fundamental questions about the constitutional division of powers and the boundaries of state autonomy within the federal system. Comparisons to existing gun laws. Examining the newly introduced emergency law to ban arms requires a careful analysis of how it compares to existing arm laws. This aspect is crucial in understanding the novelty, stringency, and potential impact of the recent legal development. Firstly, a detailed comparison with existing federal and state gun laws would unveil the specific provisions of the emergency law. It is essential to identify whether the new law introduces stricter regulations, additional restrictions, or novel measures not present in current legislation. Such comparisons can provide insights into whether the emergency law significantly alters the legal landscape surrounding firearms. Additionally, evaluating the emergency law in relation to established arm control measures helps determine its consistency or deviation from constitutional norms and precedents. Examining how the new law aligns with the Second Amendment and previous Supreme Court decisions on gun rights is pivotal. If the emergency law deviates substantially from established legal frameworks, it may face heightened scrutiny for potential constitutional challenges. Comparisons also extend to the enforcement mechanisms and penalties outlined in the emergency law. Understanding how these aspects differ from existing laws provides clarity on the severity of consequences for non-compliance. This assessment can shed light on the potential impact on gun owners, law enforcement agencies, and the overall legal landscape. Examining the nuances of the emergency law in relation to existing legislation also allows for an evaluation of its scope. Does the new law target specific types of arms, certain demographics, or particular locations? Identifying these specifics helps assess the law's potential impact on different segments of the population and its intended objectives. Furthermore, a comparative analysis should consider the historical context of gun legislation, recognizing any evolving trends or shifts in societal perspectives on gun control. This historical lens aids in understanding whether the emergency law aligns with or deviates from broader trends in firearm regulation. In conclusion, comparing the newly introduced emergency law to existing gun laws is a crucial step in comprehending its implications. This examination provides clarity on the law's distinctiveness, its alignment with constitutional principles, and its potential impact on individuals and law enforcement. By contextualizing the emergency law within the existing legal framework, one can better grasp the broader implications and potential challenges it may face in terms of legality and public acceptance. That's all for this video, folks. See you next time.